This is Jonathan Page and another RU PLC video series. Today we're going to talk about this new salary requirements under the federal labor laws, specifically the Fair Labor Standards Act. Now, if you have an employee who is a manager or supervisor or some other role, executive kind of employee, and you are paying them less than $47,476 annually or $913 weekly, then starting December 1st, 2016, you will likely have to begin paying them overtime and minimum wage, and also start complying with very rigid record-keeping requirements under these federal laws. So first, does the federal labor laws apply to your business? Well, specifically we're talking about the Fair Labor Standards Act. The Fair Labor Standards Act does apply to your business in two situations. One, so let's write that there. Does FLSA apply? One, if your business does $500,000 in annual gross revenue a year, then the Fair Labor Standards Act will apply. Or alternatively, if you've got an employee in interstate commerce, and what I mean by that is, if your employee is engaged in interstate commerce, which is across state lines, then even if your business doesn't gross $500,000, the Fair Labor Standards Act will still apply to your business. Now, this is a fairly easy standard to meet. If your employee simply swipes credit cards, then they're going to fall within the Fair Labor Standards Act. So what does that mean, that the Fair Labor Standards Act does apply? Well, in short, it means three things. One is that you've got to pay minimum wage, okay, which is $7.25 an hour. Now, likely you do meet the minimum wage requirements for your employees, but again, take the overall hours that your employee works in a work week, take the overall compensation, do the division, and that needs to come out to $7.25 an hour. Second is that you're going to have to pay overtime, which is any hour over 40, you have to pay the hourly rate plus 1.5 times that, or 1.5 times the hourly rate. And third is the record keeping. Not only do you have to keep track of every hour worked, but you also have to keep up with certain things with the personnel file, and these standards are fairly rigid. So that's what it means if the Fair Labor Standards Act applies to your business, is that you have to comply with all of these requirements. Thirdly, you need to figure out which employees are exempt and which employees are non-exempt. So there's two types of employees under the federal labor law. Exempt employees are those employees who do not have to comply with these requirements because of their job functions and because of how much you pay them weekly or annually. Non-exempt employees are those employees in which you do have to comply with these requirements, again, because of their job duties or because of how much you pay them. So fourth, you have to decide whether or not your employees, you have to do the analysis to figure out which employees are exempt and which employees are non-exempt. Now, there's a misconception out there. I've had a lot of clients in our office believe that because they pay an employee on salary, that somehow makes them exempt under the overtime and minimum wage and record keeping. That is completely false. The Fair Labor Standards Act and the regulations implemented by the U.S. Department of Labor have two tests that you have to pass. One is a duties test, and the second is a salary test. So even if you meet the salary test, if you don't meet the duties test, then you're not going to be exempt, meaning you will be subject to these requirements. Or vice versa, if you meet the duties test but don't meet the salary test, then again, you're going to be non-exempt and you're going to be subject to these requirements. The duties test looks at the job functions of the employee. So if your employee is a receptionist, likely she is not going to satisfy the duties test because she doesn't exercise much judgment or discretion in how she performs her job. If your employee is a manager or a supervisor, then likely she will meet the duties test, because she likely does exercise significant judgment and discretion in how she performs her job duties. And her opinion may be given weight in terms of hiring and firing employees. So if she's got all of that involved in her job, then she likely does meet the duties test. But just because she meets the duties test doesn't mean that she meets the salary test. This is the change that has been made under the federal labor law. There's a regulation now that is increasing that salary requirement. So even if she meets the duties test, she also has to be paid, this is beginning December 1st, 2016, at least $47,476 annually, or $913 weekly. Now, there's a caveat. 10% of this requirement can consist of non-discretionary compensation. That's $4,747. Non-discretionary is what's key about that caveat. So a Christmas bonus likely would likely not qualify, because you as the employer have discretion on when you pay that, whether you pay it, and how much you pay. On the other hand, a commission, which must be written down under Georgia law, so hopefully you have your commission arrangements written down in writing, but the commission will say things like, if you hit this sales numbers, or if you go over this amount, then you get this percentage, and that's not discretionary. As long as they're employed with you and they meet those numbers, then they get that compensation. And as long as it's paid at least quarterly, or more frequently than quarterly, then that can be counted towards this $47,000 threshold. So keep that in mind as well. So the last thing that you've got to do, once you know that you are subject to the Fair Labor Standards Act, it does apply, you know what that means. That means that for those non-exempt employees, you've got a minimum wage requirement, you've got an overtime requirement, and you've got some rigid record-keeping requirements. Then the third thing is to figure out within your employee pool what employees are exempt, meaning they're not subject to these requirements, meaning that you're not subject to these requirements for those employees, and which employees are non-exempt. And knowing that in doing that analysis, you're going to be performing a duties test as well as a salary test. Then, once you do those things, you can determine how to deal with those employees in terms of record keeping and so forth. There's all sorts of exceptions and exemptions under the Fair Labor Standards Act. For example, if one of your employees has 20% ownership, equity ownership or more in the company, then because they're a business owner with that much equity, they're not subject to this even if they don't meet the salary requirement. There are your outside salespeople don't have to be paid on a salary in order to be exempt. Outside sales, as long as they're making the sales typically at the door of the customer, then under the Fair Labor Standards Act, even if they don't receive a fixed salary, they can still be exempt. So there's all kinds of little exceptions out there, and a list of different things, and there's different types of exemptions, administrative, professional, but in general, when you're looking at employees, you're going to be looking at the duties test and you're going to be looking at the salary test. Now there's all kinds of information available on the web. You can go to the various fact sheets with the Department of Labor to get more information on this. We're happy to do an assessment for you. We can go in and look at your employees, and based on their job duties, based on their functions in your company, based on the salary that you provide them, we can tell you whether or not they're going to be exempt or non-exempt. And then if they're non-exempt, we can help you ensure that you comply with these different record-keeping requirements, overtime requirements, and minimum wage requirements. Now, just one little thing I want to leave you with. There is not some FLSA police that's out there going to every single business and making sure that the business is complying with the Fair Labor Standards Act, okay? There is the Department of Labor. They do have investigators. They do audits, but they're not, it's not a huge office, and they don't have millions of investigators out there so that they can knock on every single door. So it's true, you could get audited by the Fair Labor Standards Act, by the Department of Labor. And that's one way that you can get in trouble with not complying with these requirements. The more likely way that you would get in trouble with not complying with these requirements is that you've got a disgruntled employee who leaves their employment. Maybe they're terminated, maybe they're fired, maybe they were stealing something and you found out they were embezzling, so you fired them. They're now disgruntled. They go to an attorney, and oftentimes when they go to the attorney, they're thinking about a different reason that they're going there. Maybe they feel like they've been discriminated against, even though no discrimination has occurred. And that's the reason that prompted them to go to the attorney. A good plaintiff's attorney is going to ask a lot of questions. And they're going to start asking questions like, well, how much were you paid? And the employee may tell them $42,000 a year. Okay? And did you work more than 40 hours a week? Well, I normally worked like 42 or 43 hours every week. Were you paid salary or were you paid hourly? Well, I was paid salary. Did your employer require you to keep your time records? No. So now, even though the employee wasn't even really aware of all these requirements or even thinking about that, now their plaintiff's attorney is going to be the one who's going to send that nasty letter and is going to say that you're violating the Fair Labor Standards Act. And once that attorney gets a hold of it, that employee, it's the attorney who's coming up with the causes of action and determining their strategy for going after you. And now, under the Fair Labor Standards Act, not only are you going to owe the back wages, and you haven't kept your records well, so the employee's going to say, well, from what I remember, I was working, 5 hours additional over 40 every single week. And so they're going to extrapolate that and say, well, since the beginning of time, you've got, an additional 5 hours, and you're not going to be able to prove otherwise, and it's the employer's burden to show how many hours that employee worked. So you're going to be liable for those back wages, but you're also going to be liable under the Fair Labor Standards Act for treble damages. They take those back wages, multiply it by 3, and add that on to the amount that you were owed. So say the back wages are $100,000. Now you've got an additional $300,000 in treble damages. And then if they feel like you were intentional about this, then there could be punitive damages and other damages that they can come after you with. Now you've got this humongous lawsuit against you. That all kind of came about because you had a disgruntled employee who went to the plaintiff's attorney not even thinking about this. But that plaintiff's attorney got creative and figured out a way to come after you. So this is serious. And ensuring that you comply with these legal requirements is a way that you can avoid that liability and help you get more, help you get in that prime legal condition. This is one of those legal threats that can get in your way and can cause your company to stop. Okay, so you can get more information about these new salary requirements on the website. Specifically, the U.S. Department of Labor has a lot of fact sheets and other information that will help you determine how to comply with these new requirements. You can call our office and schedule an appointment, and we can sit down with you or over the phone, kind of walk you through assessing each of your employees and determining whether or not they're exempt or non-exempt, and if they're non-exempt, then what you need to do to be in compliance with these federal labor laws, specifically the record-keeping requirements. And then finally, you can reach out to us on our website, www.inprimelegal.com. You can call our office at 770-285-7785. You can leave comments at the comment section after this video, and we'll reply to your comments or whatever questions that you have. Until next time, on the RU PLC video series.